Welcome back. Hope everybody's had a decent go at the food, which was absolutely delicious and caters for all tastes. But get yourself a coffee or a cold drink, because we've got Jitendra Kumarage and Richard Martin to talk about something that's very topical, and that's succession issues now. You first, Jitendra.
Okay. It was good to see Tom Keeley here this morning. The very first claim I worked on, Tom was the barrister on that, on a land claim in the Borroloola-Barkly region. And some of those comments he made about young anthropologists and might have applied to me. Okay. Everyone came from somewhere else. Now, this is a comment that when I first started at the Northern Land Council, actually before that, if you've got a piece of paper with an abstract in it, there's a significant error in it. Where it says dissent on there, it says succession, I think. So this is why it's good to have lawyers look at your work, because they pick up errors like that. So the title of the presentation comes from when I... Sorry?
Sorry, it's just the writing's down there if you don't want to turn around on the big
screen.
Okay,
yep. Okay. When I first started at the NLC and I was about to head off to do some field work, Jeff Stead, who was my manager at the time, said, no, just remember everyone came from somewhere else. And it's really a reminder that things aren't as clear-cut as you expect, and that sort of turned out to be the case with the groups I was working with in East Arnhem and also in the Borroloola-Barkly region. And it just reminds you that Aboriginal tradition is very, very adaptable, and we should recognise that. So I'm going to go through pretty quickly. So what I'm going to do is I'm going to look at some early Northern Territory land claims, and these are ones where from the 80s, but groups where I went to 10, 20 years later and did other claims with. And then if I have time, I'll also go on to talk about a claim in southeast Queensland, the Uwallerai claim. So why are we talking about succession? Why are we talking about incorporation and means other than descent, or means of inheriting country other than descent? So where this comes from is Nick Peterson wrote, I think it was in 1983, that traditionally local groups in Aboriginal society were relatively small and maybe consisting of a few families only. They were under threat from demographic processes, so succession to the estates of dying clans was an important consideration, and that non-patrilineal interests can be then converted into patrilineally transmitted interests. And he also said that these processes allowed for stability over time. And the point is that those processes predated sovereignty. And it's not a new thing that groups die out, that groups get depleted, and that other people in some way take over. It's what the process is that's important. Now, very briefly, I want to really talk about inheriting country rather than just talking about descent. So there's ways of inheriting country. The common way is to talk about descent and filiation, and there are many pathways if you look at the Northern Territory situation of how descent is talked about. So it could be patrilineal descent, it could be patrilines plus matrifiliates, it could be cognatic, or a combination of those things. Adoption generally refers to raising a child that they were not born into within the same local group. We should consider adoption to be a relationship of descent, where the rights and responsibilities of that adopted person are no different to someone with biological descent. When I talk about incorporation, I mean someone who's incorporated into and in this case, a local group, say, as an adult. So you come from somewhere else and maybe a different language group, and it may not be because of the depletion of that local group. It is to regularize the position within that society or that community. So if someone comes from a long distance away and somehow gets incorporated, gets given responsibilities for country, they get married, they marry into that group and then are considered part of the group. And it can be a pathway to succession if the group itself is quite small or depleted or gets extinct. Succession at a local level occurs when local groups are in danger of extinction rather than when they are extinct. And it can occur by the successors shifting their identity to match that of the country. So the country retains its name, the language, and its spirit. Alternatively, country can become identified with the name and language of the successors. So an example of the latter would be the Gumaj succession to Lamamiri country on the Gove Peninsula. People just talk about it as Gumaj country now. Okay, I'm going to talk about the land rights claims and what you're required to demonstrate. So the Land Rights Act in its Commonwealth Act, which only applies in the Northern Territory, and I think there's quite a few people here who've worked on land rights claims in the NT, but just for the others, the Act defines traditional Aboriginal owners as being members of local descent groups, which have common spiritual affiliations to a site on the land, being affiliations that place the group under a primary spiritual responsibility for the site. And they also need to demonstrate that they forage on that land. That part is usually not, there's not a lot of discussion about that part. So claimants under the Land Rights Act have to demonstrate that they meet these definitions. But the important thing is, in the ALRA, it's really focused on the present. Who are the traditional owners now? And there's no need to demonstrate connection and continuity back to sovereignty, for example. It's really identifying who people are now, and therefore that focuses on, it allows for things like incorporation and succession and adoption to be talked about uncontroversially. Now, even though the Land Rights Act has that definition, the intent in describing a claim group under both ALRA and the Native Title Act are pretty, essentially the same. It's to identify the right people for country. So what I'm arguing is that adoption, incorporation, shifting identity, succession, they've been discussed in land claims in the NT. All of those concepts have been discussed in plenty of land claims, but also in native title claims, because native title work in the NT drew its methodology from the earlier land claims. And anyway, the processes like this continue into the present in the NT in most areas, from at least in my experience. So senior regional knowledge holders are continually thinking about and planning who should take responsibility for country that may be in danger of being left vacant. New claims, when a claim is lodged, it certainly focuses people's minds onto, well, who has actually succeeded to this country or who's responsible for this country. It makes people think about, okay, no one's been visiting that part of the country for a long time, who's responsible? And yes, it's true, the claim process sort of drives that a bit, but they also happen organically because people don't like the idea of country being left without someone responsible for it. And the ways of incorporation, and this is what I'm really talking about mainly, is incorporation in this paper, at a local level can be mediated through a variety of factors. So common language is one, geographic proximity, the same classification of countries. So it might be that they're the same subsection or section classification, genealogical connections, spiritual connections, so dreaming tracks that connect one country to the other, birthplace and conception. And not all of these need to match, but these are some of the considerations that go into identifying who might be incorporated into a group, who might succeed to a country that's the estate group is either depleted or extinct. And from my experience, there are always arguments about who actually should succeed or who can be incorporated and who has or hasn't been adopted. But there's not really an argument that these processes are not part of a traditional process. Or, so it's uncontroversial that these processes exist, but people might still argue about who fits in under those laws and customs. Now, I've done something here that, okay. Now that's the Northern Territory situation from my experience. But elsewhere, it seems that, claimants often make statements like this. You've got to follow the bloodline, got to go back to where your apical ancestor came from. They make them to each other, they argue in meetings, and they're unwilling to accept individuals or families whose origins may be elsewhere as members of the group, or they do so sort of reluctantly, even when, you can demonstrate that under their traditional laws and customs, these processes must have taken place in the past, because you can look at the genealogies of people and see that they have been incorporated in some way, but they won't accept that that's a current, that it ever happened in some cases. Okay, so I'm going to look at the Warramunga land claim, which was, Julie can correct me, but I think it was mid-80s, around Tennant Creek, which is about 500 k's north of Alice Springs. And it's called the Warramunga land claim, but it included some groups which were affiliated to other languages. So, and they included Wakaya, Alyawara, and Warlpiri. And what we'll see is that the language didn't really have much impact on who was identified as a successor to certain estates. The evidence about the composition of the groups that were involved in the claim showed that there was a lot of interaction between Warramunga-speaking people and their neighbours, and a commonality of laws and customs in sort of native title terms. And this can be demonstrated by examining the history of one of the groups. I'm only going to look at one, which is the succession to an estate called Mitatu, which is mainly on Karandi Station. And it's primarily associated with the Warramunga language. So people understand that Mitatu country is Warramunga country. And to the south is Kaitij country, language country, and south of that is Alyawara speaking. So Alyawara is like two languages down on the map. The last remembered member of the Mitatu group was a woman only known by her skin name. And by the mid-20th century, there were no surviving members of the original patriline. And it was being looked after by matrifiliates, so people whose mothers were from that group, or maybe even further back. And it included a man named Lame Tommy. And I'm going to quote this, or I can just leave it up there. But Justice Maurice made the following comments. Lame Tommy, sorry, by the way, was from another group called Arawajan, which had similar issues. The background to the ownership of both countries is similar. The landowning patrilines of Arawajan and Matatu had become depleted. The remaining custodians of these places recruited young men whose father's country lay elsewhere to replenish the Matatu and Arawajan groups and to carry on their ancient responsibilities. The result is that they regard these places and not their actual fathers' countries as their countries, and it is the ownership of these places which they will pass on to their children. Now, specifically, there was a man called Japari Wickham, who was an Alyawara speaker from another estate several, 100 kilometres away. But he had lived on Matatu country in a Warramunga-speaking estate for over 40 years, and he gave evidence that this place here, Matatu, because they'd been given me the witness, paint, everything. That's why they put me in this place or that place. Paint and everything means the designs, the songs, everything to do with that estate, the knowledge of country. And now this was in I think evidence was from 86, 87, I think, and Justice Mauritius' report was 1988. I did some work with the same group 20 years later. And Alyawara lawmen, who were still some of the most knowledgeable people about this Warramungu-speaking estate, told me that Lame Tommy thought he would fit Japati in for this country because he'd been born here and taught Japati Matatu ceremony. So it was a planned succession by people who were from a neighbouring group. Right? It wasn't the actual members of the group that made the decision about the succession. It was on a regional basis. Now, Japati was from this group called Akuranch. But the Akuranch group didn't succeed to Matatu country. It was just one person from that group, Japati. He became Matatu. So his succession was based on factors affecting him personally. His sisters, for example, weren't part of the succession. His birth at Matatu country was important. So not only did his family succeed to this estate, nor did the Akuranch group as a whole, and nor did Alyawara people as a whole. It was quite personal. And language didn't have anything to do with the succession. Some people do say still that Japati Wickham had two countries. His original one, his father's one, and the one he succeeded to. Now, at the time of the Warramunga land claim, there was discussion about another young man who had been born on Matatu country. He was called Pilot Car. The reason he was called Pilot was because as he was being born, a plane landed on the airstrip. And his father was a Walpuri man. So Walpuri country is several hundred kilometres away. And this Walpuri man, Darby, had left his own country and come to Warramunga country. And he was escaping some of the frontier violence. Pilot Car's mother was an Alyawara woman. So his ancestry was Walpuri and Alyawara. And Japati Wickham gave evidence that Pilot was born or conceived at an important place in Matatu country, but nothing formal had yet happened. So they just talked about it, but it hadn't incorporation or succession hadn't happened. So he wasn't found to be a member of the Matatu group by the judge. Now the situation's changed because of his birth in Matatu country, being the correct skin classification, long-term residence, and the fact that he's now acquired a lot of knowledge about the country. When I worked with him about, it should have been 10, 15 years ago, he was recognised as the main person for Matatu country, right? Despite his origins being quite different to that estate's classification. The language of his parents had no bearing on Pilot's incorporation into the group. And in his case, there's no suggestion that he's retained interests in his father's country or his mother's country. Okay, so we can see this much from this claim, that planned succession to local areas are mediated by birth, conception, long-term residence, and the bestowal of ceremony and sacred objects for that country. We can see that the regional law holders and knowledge holders are important in mediating that incorporation and succession. Successions can happen across linguistic lines. Incorporation can happen across linguistic lines. You can have the possible loss of rights in your ancestral country, but you can also have the opposite, that you retain rights to ancestral country. And given that I spoke to Pilot and these other lawmen recently, it just shows that these processes in the NT are still continuing. Okay, I'm going to talk about another. How are we going for time? Is that all? Okay. All right. The Malak Malak and Upper Daly, I'll leave the Upper Daly aside. This is the Malak Malak only. The red, this is the Horton map. I'm using it because it's colourful and couldn't make up anything else, but it misses the group called Kamu. Anyway, so in the 1980s, there's two other claims of local groups identified with the Malak Malak, Kamu, Wagaman, Ngurumeri and Wadaman languages in the Daly region. In the Daly claim, Sutton and Palmer posited that all Malak Malak and Madangale local descent groups had combined under the name Malak Malak. They said the combined Malak Malak group was jointly responsible for all Malak Malak and Madangale country, including those of extinct estates of those languages, and that the combined Malak Malak group had also jointly succeeded to all the country identified with another neighbouring group, Kamu, that only had one old woman left as a patrilineal member. Now, so that elderly patrilineal, she was 8 years old and blind, and she was the only one alive. And the other Kamu groups had been wiped out, but following a patrilineal model of land ownership, this woman's children weren't advanced as claimants. Justice Tui accepted that the Malak Malak group had succeeded to all Malak Malak and Madangale estates, including the extinct ones. He also found that at some point in the past there was a group called Kamu, but that a Kamu local descent group, as required under the ALRA Act, effectively no longer existed. He found there was no evidence to establish a takeover of Kamu country by the Malak Malak, but that in time ownership may vest with a group other than Kamu. It just hasn't done so yet. So the principle of succeeding between one language group to the other is established, but not the fact of it having happened. So in this we can see that succession is part of the traditional laws and customs of that region. Two language identified groups, each consisting of several former estate groups, had effectively merged, and one language identified group can in principle succeed to the country of another neighbouring language identified group. Now in time I did work with the Kamu later on, like quite recently. Their rights are now recognised as a group. They were able to establish that they had jointly succeeded. There was only one family here, the descendants of that one single woman, but her descendants were able to establish that they had jointly succeeded not only to their country, but all Kamu country under a cognatic system, because if you went patrilineal, of course, you don't exist. Okay, I'm going to skip over all of this. Okay, now this is more, how much time have I got? Is it like a minute? 2? Okay, I'll go quickly. So other means of inheritance, other than descent, are difficult in settled areas or difficult to discuss in more settled areas. Because by the time we get involved as anthropologists, often there's already a claim, there's a boundary, there's a list of apical ancestors, and a group description referring to descent, often biological only, from those ancestors. Inevitably, the research reveals a more complex situation. Claimants are unwilling to accept individuals or families whose origins may be elsewhere. And so the challenge is, how can processes such as incorporation be discussed in the absence of that sort of rich data that you get when you talk to people still in parts of the Northern Territory. So I think we can draw inferences from other data. So genealogical data, evidence of movement of people and acceptance, and their acceptance by the group, and the observance of traditional practices of the group they moved to. Now, this is probably something I'm not going to get to finish, but this is the Uwalari claim that I worked on in southern Queensland, and Cherie, hello there, Tim, will know all about this. It's it's obviously in the settled area. The group, this is again the Horton map, and the group doesn't exist on that map, but that's roughly the area it occupies. If you know Brewarrina and Walgett, it's sort of north of there, heading into Queensland. The claim that I worked on is the Queensland part of it. Now, so the group is Uwalari. It's a similar language to Gamilaroi, which is neighbouring country. There are other language groups, obviously, to the east and the west that are unrelated to Uwalari. But they've got very similar laws and customs, and my argument was that the laws and customs are completely compatible, even though the languages are different. So because the laws and customs are similar and compatible, it's a regional society that includes the Uwalari claimants and all of their neighbours. And during the research, the research revealed a great deal of movement between these groups, such that some families were incorporated into a neighbouring group and have shifted their identity. Now, I'm probably not going to have time to talk about this too much, but in the neighbouring claims, although it wasn't stated explicitly that there was incorporation, when you looked into the reports, there was evidence of incorporation, because some of the apical ancestors were acknowledged to have come from a different neighbouring group. And this was in the Kuma claim, where one of the apical ancestors was a Gamilaroi woman who was born in Uwalari country, but everybody said she was Kuma, and she was recognised as a Kuma apical. And there's no argument amongst the Kuma people or their neighbours about whether she's Kuma or not. It's just that the record is pretty clear that she came from elsewhere. And the same thing is evident with the Uwalari claim. I think 6 of the apical ancestors are ones that look to have been incorporated in some way. 3 of them from the Kuma group, 1 from Murawari, and within a generation or a maximum of 2, their descendants are just accepted as Uwalari. In some cases, they're the ones who hold the most knowledge about the group and its language, its traditional laws, and their sites, yet they were clearly from somewhere else. And my argument is that we should really think of descent as just one of the ways of inheriting country. And there are other ways. And the important thing is that the laws and customs allow it to happen. And if it does, that means that even though people are being brought in from elsewhere, from neighbouring groups, there's continuity. back to sovereignty, even though the people might not go back on a clear descent line back to sovereignty. I might leave it there.
Thank you. We'll have
Okay.
questions at the end of Richard's.
Okay. Do you need the computer?